take their seats quickly, please. Today, a team from Monash University will represent the claimant. They're sitting on stage left to my right now. The team from City University of Hong Kong are respondent, and they are sitting to my left, stage right. Our panel today is chaired by Professor Dr. Eckart Brodermann. Professor Brodermann is the Managing Director of CIAC, which is the Chinese-European Arbitration Centre. He is assisted by Dr. Vienna Droulers, who is the Director of the Caracas Chamber Arbitration Institution and is presiding IFCA. And to his left is Lord Hamilton, former Lord President of the Judiciary in Scotland. And with those introductions and announcements done, I turn the stage over to Professor Brodermann.
Good morning. Can everybody hear us? I would have to start with some housekeeping announcement before we start the actual pleading. First, for the purposes of this final, please, I'm deemed that as a Managing Director of the Chinese-European Arbitration Centre, I'm distinct from Professor Dr. Management, because in real life, the Managing Director of an arbitration centre would not accept to sit on an arbitral panel hearing a case administered by himself. We suggest that each side will have 35 to max 40 minutes for presentation. For each side, split approximately 50-50. If counsel on one side raises a point of particular interest, the arbitral tribunal may invite an immediate response from the other side. Time will be monitored so that there is, as close as reasonably possible, a 50-50% allocation of the time. I hereby declare this arbitration proceeding in the matter Mediterranean Expert Supply Company versus Equatoriana Clothing Manufacturing Limited open. May I invite counsel for claimant to introduce yourself.
Members of the tribunal, my name is Alan Sargent and I appear as counsel for the claimant alongside my co-counsel Martin John.
Thank you. It would be very helpful if you try, as I try to do it, to take the microphone as close as possible to your, even put it a little bit closer, that makes it easier for everybody to hear. Thank you, Mr. Sargent and Mr. John. May I now invite the counsels for respondents to introduce yourself.
Good afternoon, Mr. President and members of the tribunal. My name is Eric Ng. Sitting on my immediate left is Ms. Jacqueline Ng, and together we represent the respondent in this matter, Equatoriana Clothing Manufacturing Limited. I will be speaking in regards to the procedural issues regarding Mr. Short's witness statement and the Article 96 reservation, while my co-counsel will be addressing the matters regarding amendment of the contract and avoidance of the contract.
Thank you very much. My name is Eckart Brodermann, and I'm assisted by...
Yes, good afternoon. My name is Vienna Austria.
And
I'm Lord Hamilton.
so then I would first like to ask both counsels whether you consent to be brought a few hundred pupils along with us. Would you have any objections in light of the confidentiality arrangement that some pupils are here to learn?
No.
Thank you. That being clarified, then I will walk through a couple of formalities. The notice of arbitration was to be filed with CIAC on 2 July 2013. With letter of 6 September 2013, CIAC has informed the parties of the constitution of the tribunal. Procedural orders number 1 and 2 have been issued on 5 October and 1 November respectively. Both parties have already explicitly confirmed jurisdiction of this tribunal in the telephone conference of 4 October. Briefs have been exchanged. Procedural order number 1 set a hearing date for today, 28 March, at the final of the Willem C.Vis Moot competition. I assume, Counsel Mr. Sargent, that you wish to still pursue the claims set forth in the statement of claim of 1 July 2002?
That is correct.
And may we also assume, Mr. Ing, that correspondence to request rejections of complaints?
That is correct.
Then we would like to proceed as follows. We had some deliberation and we would like to start with the issue which we think has the highest economic impact. That would be the issue of breach of contract avoidance. We would therefore invite the claimant now to make any comments they wish to make on this issue.
Members of the tribunal, may I clarify, are you asking to hear argument on the claim for both $27,500 and the claim for $2.1 million at this point in time, or just the $2.1 million?
One technical thing, I have difficulties understanding anything. Not well. Maybe we have to then still try to put the microphone a little bit further away because we have to hear you correctly. I couldn't understand a word of what you said.
Do apologize.
Okay, no, it's technical. It's not your fault. Perfect.
Are you intending or asking to hear argument on the claim for $27,500 and the claim for $2.1 million, or just the claim for $2.1 million at this point in time?
What we do have in mind is to start with the issue of economical breach, of the economic importance of the breach of contract, the issue of avoidance, everything which you may address at that point. And we very much want to concentrate on that point. And then later we'll come back to the issue of late delivery.
Indeed. Okay.
That is indeed the case. As counsel for the claimant, I will begin. However, I would like to clarify the time allocation that we do have today between both myself and my co-counsel, and also the rights of rebuttal of the respondent. Is my understanding correct that you would first like to hear in or around 15 minutes in the claimant's claim for breach of contract, that you would then hear the respondent responding to each and every one of those points, and then you will move on to the delay delivery proceeding?
Dear counsel, we have heard now 9 arguments. This is a tense meeting we're having in this case, and we really would like to bring this case to a close. And in light of this impression, we really would like to invite you to start by concentrating. It will take time, and if necessary, it will take up to 20 minutes time to concentrate on the issue of breach of contract. So you have all the time you need. Please proceed for this issue, which we consider most important at this point.
Certainly. Thank you, Professor Brodermann. As claimant, we do greatly appreciate the opportunity to speak about the substantive issue in this dispute, which is a matter of breach of contract and indeed avoidance of the contract as deemed by a fundamental breach. The claimant submits that the respondent's agreed use of child labour in at least one of its plans constitutes a breach of contract such that liability is established under Article 45 of the CISG, and that as such either there is a breach of Clause 12, being an express clause of this contract, or indeed that there was a failure to adhere to a particular purpose made known under Article 35 2b. Now, I will flag that purpose for the members of the tribunal now, and that would namely be that these goods were not fit because the respondent used child labour in its business, that these goods were not fit for receipt or to be received by an ethical company, in my client being the claimant. I'll also address the tribunal with regards to the avoidance of the contract. However, at this stage and from the outset, I would like to make clear to the members of the tribunal that our fundamental claim here today is one of breach of contract. If breach of contract is established, then in the subsequent hearing where we will discuss quantum of damages, we will be seeking to establish a claim under Article 74 of the CISG for damages, and as such, whether or not the tribunal does find that there was a breach of contract, that there was avoidance of the contract here, will not prejudice our claim to claim damages under Article 74. So with that, I will move to the issue of breach of contract and spend the majority of my time addressing that point. Yes, sir.
Can I understand that you are also claiming for repayment of the contract price as well as for damages?
In the statement of claim, we have stated that we are seeking restitution of the full contract price of $550,000. We do, however, note that in a subsequent hearing where we will be discussing the quantum of damages, that this may well be a mistake, and indeed what should have been written there was the $74,500, which constitutes the difference in the resale price and the full contract price. The resale price being $470,000 for 99,000 polo shirts, and the original contract price being $550,000 for 100,000 polo shirts. As such, I would like to move directly to the issue of breach and be very clear with the tribunal here what facts we're working with. In the last hearing, as Professor Brodermann did allude to, at least the hearing was alluded to, the parties came to a procedural agreement that the respondent had agreed for it to be assumed for the purposes of this arbitration that child labour was used in at least one of its plants, albeit not on the particular goods the subject of this contract. Now, it is our claim in a nutshell, tribunal, that clause 12 of this contract, on a plain meaning reading, in fact imposes an obligation on the respondent not to use child labour in their business and indeed in any one of their plans. The tribunal would like to turn to me to page 12 of the evidentiary record and direct their attention to clause 12 of the contract. As I've said, the respondent has agreed to using child labour in at least one of its plans. As such, if we can assume for a moment, and in fact it is reasonable to do so, that every plant of the respondent's business constitutes part of its business, indeed the plain understanding of the word business being commercial activity, each and every plant of the respondent must in fact be part of its business. As such, by agreeing to using child labour in one of their plants, tribunal, the respondent has in fact agreed to using child labour in their business. And if you'd like to direct your attention to the final four words of clause 12, you will see that that is precisely what this clause prohibits. This clause speaks about adhering to certain high ethical standards in the conduct of their business. And as such, on plain meaning alone, we can see here that by using child labour in at least one of their plants, the respondent has in fact breached clause 12. This is of course assuming that this procedural agreement was based on an understanding that there was an obligation not to use child labour, and if the tribunal is at all concerned on those matters, I will address them. However, it is our interpretation of the procedural agreement that in good faith what was to be decided today was the breadth of this obligation rather than whether there was an obligation not to use child labour. And I'll take you into that.
Can I just help you a little bit, please, on the question of the approach to clause 12? Clause 12 is heading policy, and introduced by the words, it is expected. That might be said to be in contrast with other provisions of the contract about delivery date, terms and things of that sort, was described as something is or must be. Is there an argument that what is expected is not obligatory?
Well, Lord Hamilton, in a vacuum, yes, there is an argument that expected or the language of expectation can have one of two meanings. Either it can be one of obligation, such that the members of the tribunal expected counsel to be on time for this hearing, or it could be one of a more anticipatory nature, such that it is expected that the weather tomorrow might be a bit better than it is today. In this particular context, though, and I note, Lord Hamilton, that there are differences here in the language used in this clause. However, first of all, I would point out that we don't in fact have all of the clauses of the contract here before us, unfortunately. At least by analogy, at that point, we would need more information to draw the strong point that could be made there. Most importantly, however, this clause can only ever be read as an obligation. Firstly, because it is included in the contract, and I'm sure the members of the tribunal would agree that a contract tends to be an exchange of mutual obligations between parties. It's something that's written in the contract, it's presumed to have some meaning, and indeed we could go as far to say it can almost be presumed to be an obligation unless there's arguments to the contrary. Most importantly and most tellingly, however, and I will take you to this prior history between the parties, however, the only reason that the respondent was in fact able to read clause 12 to begin with and read the word expected was because they were subjected to an audit and they're required to pass that audit in order to be listed as a supplier. So in this context, in fact, the only way that expected can be read in the word policy is one of obligation. However, again, I'll remind the tribunal of the procedural agreement between the parties, where it seems to be that really the question that we are seeking to be determined today is the breadth of that obligation rather than whether it specifically is or the content thereof. So crucially, moving to that question of the breadth, I've already mentioned to the tribunal on plain meaning this clause covers the respondent's business and is not limited to a particular contract, being this particular contract in question. This is supported by a contextualised reading of clause 12. We understand that under the CISG, articles 8.2 and 8.3 become relevant here, and as such, we would submit that a reasonable person of the same kind as the respondent, in reading clause 12, would have the same understanding as my plain meaning and characterisation of it. There's two crucial pieces of prior conduct between the parties here as relevant under Article 8.3, namely the policy document that's referenced. However, crucially, and as I pointed out to Lord Hamilton before, the crucial piece of evidence here is the audit. Claimant submits that if the audit itself was an audit of the respondent's business, then therefore the clause 12 must also impose an obligation across the respondent's business. Unfortunately, on the evidentiary record before us today, we don't actually have specific documentary evidence as to what that audit covered, and that is indeed unfortunate. However, I'll take you through why there is enough evidence to demonstrate that it is reasonable to infer that that audit was of the respondent's business and was not limited to a particular contract, as I'm sure we will hear the respondent contend. With that, there are three main points as to why this audit would be presumptively broad. The first of which comes directly from the evidentiary record, and I invite the tribunal to turn to page 52 and direct your attention to clarification 5. Clarification 5 is a question as to whether the respondent adhered to policy of Oceania Plus in previous contracts either with the claimant or other members of the Oceania Plus group, and indeed to paraphrase the answer, they have adhered to that both with contracts with the claimant and Oceania Plus. In the second line, however, it states that it's not completely clear whether that also applies to the respondent's dealings with other companies. And crucially, the third sentence states that the 2007-2008 audit raised concerns in this regard, which incidentally were largely dispelled by the ensuing discussions, as indeed that would be the only way this audit would be passed. It is the claimant's submission, however, in the tribunal that given that these concerns were raised in an audit which was related to a policy document, it would be reasonable to infer that that policy document itself actually related to the respondent's business and not merely to the particular goods in contracted for, and as such that the obligation also extended to the respondent's business in support of that plain reading meaning of clause 12. Further to this, we know, or we can imagine at least, from the practical realities of conducting such an audit of a clothing manufacturing firm, that this audit would necessarily be of the respondent's capacity in their business to adhere to this ethical standard, rather than whether or not they can move their child labour around, if you will, to be on one contract at one time, on one production line at another time. And the reason for this tribunal, if you can imagine yourselves being the auditors in this regard, you're auditing in regards to a policy document that is particularly concerned with the use of child labour. You arrive at a clothing manufacturing firm, and perhaps the first thing you might notice is a loading bay. You might walk through that factory and you might see a sewing room, you might see a cutting room, you might see any number of different types of activities going on in the production of clothing. And when doing so, you would be asking yourself, does the cutting room adhere to the highest ethical standards? Excuse me?
Everything's fine.
Thank you.
2 minutes more.
Thank you. Do the cutting rooms adhere to those highest ethical standards? Do the sewing rooms adhere to those highest ethical standards? That audit itself, the practical reality of it, is necessarily broad. Indeed, had you seen a child in the sewing room, the respondent's submission would in fact be that had you seen that child in breach of the policy, you would then need to seek an assurance, or we would need to seek an assurance from the respondent that that child would never be used on the particular goods contracted for. Now surely, Tribunal, if that were the respondent's submission, then there would be no point auditing in the first place, and we could have simply relied on putting Clause 12 into this contract. The point is that we don't only rely on Clause 12, we conduct these audits, and these audits, it's reasonable to infer, are broad, and as such, broad enough to go to the respondent's business, and as such the obligation would do so also. Mr. Jones, no? So, I also articulated, I note the time is running thin, I also articulated that we would have a claim also under Article 35(2)(b) of the CISG. In terms of the relevant evidence going to a particular purpose made known, namely that these goods were to be fit to be received by my client as an ethical company, we would acknowledge that the body of evidence I've already taken you to, namely Clause 12, the audit, extensive discussions following that audit, crucially also the respondent in fact intervened in the affairs of the supplier once it had been established that they use child labour and how to manage a SACT. That same body of evidence would go to an Article 35(2)(b) analysis. The only reason why you might want to apply Article 35(2)(b) rather than Clause 12 in this instance, as I've presented it, is if, as Lord Hamilton mentioned, if any of you were concerned with the obligatory nature of Clause 12 or indeed its certainty, which I've articulated is not the issue today, but if you were, you could use the same body of evidence to find breach under Article 35(2)(b). With that, Tribunal, the claimant submits that there was a breach of contract giving rise to a claim of damages under Article 74. Very briefly on the issue of fundamentality of breach, as we have been asked to address also. The claimant submits that by using child labour in their business, the respondent has in fact substantially deprived the claimant of what it was entitled to expect under this contract, and that's under Article 25 of the CISG. This essentially goes to a question of the importance of the contractual expectation of my client in inserting Clause 12 at the time of contracting. And the most crucial piece of evidence here, Tribunal, is the nature of this ethical obligation. If you found that there was a breach of Clause 12 being a breach of an ethical obligation, is that really something that can be subdivided or compartmentalised? An ethical obligation is either ethical and met, or it is unethical and not met. If the respondent's submission is that they use child labour in parts of their business and not others, and that therefore they can still be ethical, this simply can't hold, and as such we would submit that there was a fundamental breach of contract.
Thank you very much, Mr. John. We would be intrigued, first of all, Mr. Hing, or Mrs. Hing, who is going to plead whether you consent, whether you agree with what you just heard.
No, indeed not, Mr. President and members of the Tribunal. Mr. President and members of the Tribunal, this case is about intentions. The claimant essentially is denying what intentions they have with the contract. They're seeking only to shift the losses onto the respondent. In this regard, I will respond directly to the arguments they raised in the issue of child labour and do so in the order that they were raised. The opposing counsel first dealt with the scope of Article 12 of the contract. In alleging that there was a breach of contract, the claimant has claimed that the scope of Clause 12 extends to all the respondent's operations. That is not the case here. I invite the Tribunal to note that this contract is a specific contract of sale for a specific sale of goods, and it is only in relation to the polo shirts under this contract. Had the claimant wanted to bind my client to broader and more extensive obligations, it ought to have entered into a framework agreement where general obligations and rights are delineated. They had the perfect opportunity to do so when my client was listed as a supplier for the group. That did not happen. And therefore, the respondent's main argument is that this contract and the words therein must be interpreted within the four corners of this contract. The fact that the policy does not extend so far is also corroborated by Thomas Siren's understanding of the ethical policy. This is important because domiciliary and the claimant shares an ethical policy as this part of the same group. I refer the tribunal to page 18 of the record, claimant exhibit 5, paragraph 4. The first line of that last paragraph, reads this: I need not tell you that the use of child labor in the production of clothing for our stores is a major violation of the policy. Domiciliary's understanding, therefore, is that a violation of the policy only occurs when it relates to the polo shirts. This corroborates with the respondent's argument that, in fact, the parties' meeting of minds was on a more narrow scope of Clause 12. Furthermore, the opposing counsel relies on Article 2 of the CISG to hold that a reasonable interpretation of Clause 12 would also extend to the whole of the respondent's premises. Again, going back to the very knowledge that this is a specific contract, it cannot be a reasonable interpretation to understand that Clause 12 would go so far. And this is supported by the fact that the policy, although referred to, is not referred to in isolation. When the policy has been referred to in the contract, Clause 12 supplements it with other words, that is, in the conduct of their business. Reading it within the four corners of this contract, that would limit the scope of Clause 12. But moreover, as the conduct of their business are terms which are open to more interpretations than one, because the pronoun there can refer to Oceania Plus Enterprises, the only company named in the clause. Second, it can refer to the parties of this contract, that is, the business being transacted on this contract between the two parties, therefore relating only to polo shirts. It can also conceivably relate to the respondent, in which case it would cover the facilities. However, in that brief discussion, I've already talked about three possible interpretations. On the doctrine of contra preferentum, therefore, since the claimant is relying on this clause, it should be interpreted against them, and a narrow understanding should be adopted by this tribunal.
Counselor, yes, a small question in this context. Should the tribunal give any regard in a systematic analysis of the contract that you also chose Danubia as a place of arbitration and as a seat of this arbitration, Danubia being a member and a country of this UN Global Compact concept, which indeed requires effective abolishment of child labor? Is it something to which we should give any consideration?
Indeed, it is true that all the states concerned in this arbitral proceeding are subscribers to the idea that child labor should be eliminated. So is my client. My client is also committed to the efforts to eliminate child labor throughout the world. However, according to Professor Peter Schrechter in his article, Non-Material Damages, Recovery under the CISG in Pace International Law Review 2007, I quote, "It is uncertain to what extent different parties share the same convictions and are willing to act accordingly. The respondent is not contending that highest ethical standards would cover child labor, but we are contending that a breach simply did not occur in these facts. Because, after all, the respondent does act in relation to child labor, but it adopts a corrective approach. This is a reasonable approach suggested by the International Labour Organization itself in the guidelines on how employers can eliminate child labor, published in 2007, which on page 35 says this, that in order to forbid the use of child labor, where child labor has been detected, then a corrective plan is required and to be implemented by the supplier. That is exactly what my client has done back in 2007. We had sufficient documentary proof back then, which has been found by the Tribunal in Procedure Order 2, Clarification 3. Upon conclusive evidence, my client moved promptly to dismiss a manager at a subcontractor's firm. In our present case, those facts do not arise because according to Procedure Order 1, The parties have only assumed, for the purposes of this arbitral proceeding, that there has been child labor, and we have also agreed that we would not request the tribunal to engage in further investigation of the issue. There is no such conclusive evidence. A breach of such an obligation simply did not arise on the facts. Moving on to the opposing counsel's argument on particular purposes. Article 35(2)b requires that a particular purpose has to be delineated, but Article 35(2)b contemplates that the particular purpose relates to the goods. And for this, I refer the tribunal to the Secretariat Commentary on Article 35. In paragraph 7, it describes a particular purpose. That a buyer should describe the goods, decide by describing the particular use to which the goods are to be put. This special relationship, or this exclusive relationship with the goods that the particular purpose must have, shows that using child labor in other parts of the facilities not concerned with the polo shirts does not breach the particular purpose that the claimant has alleged. Because in isolation, the goods, that's the polo shirts in this case, were not affected. In isolation of those other more remote environment, the goods are fit for their purpose to be sold. Therefore, there has been no breach on Article 35(2)b. Mr. President and members of the tribunal, proceeding now to address the opposing counsel's arguments on fundamental breach. The opposing counsel argued that where for a fundamental breach to be found, it must be that an essential term or an essential quality of the goods or the contract are affected. However, according to Professor Schlechter and Schwenzer in the commentary on the CISG, the very fact that Article 25 does not protect all obligations under the contract. Where parties find that terms are essential, they should have made it clear. Furthermore, according to the cobalt sulfate case, Bundesgerichtshof, 1996, in Part 1, where the court was deciding what constituted a fundamental breach, it had held that it is not enough that the buyer cannot sell it in the intended country of export. A fundamental breach would only occur where, and I quote, export to another country was not possible. That is not true on the facts. They managed to sell it to Pacific Trading for $470,000 US. That sale, the possibility of sale alone, is enough to disqualify the finding of a fundamental breach. This line of thinking is also supported by Professor Schlechter and Schwenzer in the commentary on the CISG, 2010, on page 428.
Yes, excuse me, Ms. Ning. How would you explain the fact that if you say the shirts were actually sold as they were supposed to be sold, wasn't that a very specific purpose to be able to sell the shirts at the moment the stores opened for the season? Was that not the purpose of the contract?
Madam Arbitrator, the respondent argues that the particular purpose that has been alleged of sale in Oceania has not been established. As previously argued, that particular purpose has to relate to the goods. The goods itself, in isolation of the knowledge and how the media revealed its association because of other parts of the facilities, should not affect the particular purpose. The goods itself were that particular purpose. But more importantly, if the particular purpose is for resale in Oceania, the only thing that the respondent knew was that the goods were destined for the Oceania market. However, the cases supports that mere knowledge of the destination of the goods is not enough to find that the particular purpose was made known at the time of contracting. Therefore, the second requirement under Article 35(2)b also fails. Therefore, the tribunal does not have to consider a breach of Article 35(2)b and whether that amounts to fundamental breach. Yes.
Perhaps a question to both counsels in this context. Should the tribunal consider any test of reasonableness in interpreting the question of what was ethical or not, or whether that related to it?
If I I understand correctly, Mr. President, that is whether the tribunal should consider reasonableness as regards conforming with Article 35(2)b.
Reasonableness in terms of whether it's reasonable that we consider that production with child labor somewhere else as being a violation of this clause.
Oh, indeed, Mr. President, the respondent argues that it is not reasonable to consider that using child labor in other of its facilities unrelated to the polo shirts would breach Clause 12 of the contract. Returning to a previous argument, this contract must be seen as a specific contract for a specific sale of goods. This is because had the claimant wanted to impose broader and more extensive obligations, the normal course of business, a reasonable course to take, would be to enter into a distribution contract or a general framework contract at the time when the respondent was listed as a supplier. This did not happen, but contracts were entered with each and every time there was a sale, and therefore each and every contract should be regarded in isolation as its own event. Interpreting Clause 12 in that light, therefore, in the conduct of their business only extends to the production of the polo shirts.
I'm seeing Mr. John is kind of sitting in his chair to rebut on this point. You want a minute on that?
Professor Brodermann, I would like a minute to rebut on a number of points. However, I would like to answer your question with regards to reasonableness and then see if counsel the respondent does need some time to finish her submissions. In terms of reasonableness being relevant to Clause 12, Articles 8.2 and 8.3 can be of assistance here of the CISG, which state that when Clause 12 can be interpreted according to the understanding of a reasonable person of the same kind in the respondent's position, and that was addressed in my submissions as a secondary point if you weren't to be satisfied with my plain meaning analysis of Clause 12. Here, a reasonable person would have been aware of what Clause 12 was doing, imposing an obligation across the business because of the audit process that was conducted, the extensive discussions following that audit process, representations made by the respondent before they were even under an obligation, whereby they said that they were instrumental in having a supplier's manager sacked that was associated with child labour, and for these reasons a reasonable person would have understood the ambit of Clause 12. Now, Mr. may wish to continue, or I can continue in rebuttal. It's up to...
I think we wanted just answers to the questions that they come, and I shoot another one at you. Sorry for the relaxed language, but we were intrigued to know whether we should give any consideration to the fact that Article 12 appears to be a standard clause brought into the contract by claimant side.
We acknowledge that the facts suggest in clarification 4 on page 52 that this is a standard clause of companies in the Oceania Plus group. We also note, however, that this contract was negotiated between the parties. I believe perhaps, Professor Brodermann, you're alluding to the argument made by counsel for the respondent that in some way this clause should be interpreted against the drafter if the drafter were in fact my client, also referred to as contra proferentum. Contra proferentum should not apply in this case because under the CISG, whilst it is a recognised method of interpretation under the CISG, we need to acknowledge the fact that Article 8.2 and 8.3 are considered also as tools to interpret contractual clauses. Therefore, in order for contra proferentum to come into play, Professor Martin Schmidt-Kessel in Schwenz's commentary on the CISG, Edge 2010, states that resolving certain ambiguities that could not have been resolved under Article 8.2 is the only time that contra proferentum should come into play. In fact, as I've demonstrated, if there is any uncertainty here, can certainly be resolved through looking to that objective analysis under Article 8.2 and 8.3.
Thank you, Jim.
Mr. President, members of the tribunal, the respondent will reply to the point on contra proferentum. The opposing counsel has said that contra preferentum should not apply, because Article 8.2 should first be resorted. However, that is rather a contradiction. According to Professor Lukowski, and I quote from his book, Understanding the CISG in the USA, 2004, on page 46. The CISG Article 8.2 is supplemented by the internationally accepted contra preferentum method of interpretation. Contra preferentum appears to be part of Article 8.2 of the CISG. But more importantly, as the opposing counsel has pointed out, Clause 12 is a standard term. It is a standard term that has been written with legal advice, and according to the Oxonica Energy and New Tech Limited case at the Court of Appeal 2009, referring to the maxim contra preferentum, the court had held that this maxim operates most comfortably in the case of standard clauses. This is precisely what we have on the facts, and therefore, according to this doctrine, it should be interpreted narrowly that Clause 12 does only refer to production concerned with the polo shirts, and not any more than that. Thank you.
The tribunal please is another minute to rebut some other substantive points made by Mr.
That's granted. Please proceed.
First and foremost, counsel for the respondent spent some time describing to the tribunal why this somehow wasn't a particular purpose made known, being namely resale of the goods in Oceania. However, I'd like to remind the tribunal that at no point in my presentation, in my submissions, did I characterise a particular purpose under Article 35(2)(b) as being resale in Oceania. Indeed, we understand there may be problems with this particular characterisation of a particular purpose. Instead, I characterised the particular purpose as these goods being fit to be received by an ethical company. And as such, the submissions made by counsel for the respondent are simply not in response to the claimant's submissions. Secondly, I'd like to move to refer to counsel for the respondent, reference at the beginning of her presentations that this clause should be interpreted in terms of the four walls of the contract, and this would go back to Professor Brodermann's observation that Articles 8.2 and 8.3 of the CISG are in fact relevant here, and under Article 8.3 we can have regard to all the relevant circumstances, which I indeed took you to in my submissions. Thirdly, counsel for the respondent took you to a letter from Gertrude Schnippel, who is a representative of Domicilrun. Domicilrun is the sub-purchaser. They're the ones that my client unsold, the company that my client unsold these goods to. In that, they drew your attention to a particular line, which seemed to suggest that Gertrude Schnippel understood that the goods, that her grounds of avoidance, or somehow that related to the particular goods produced for this contract. I need not remind the tribunal that Gertrude Schnippel's grounds for avoiding the contract with my client are almost certainly completely different in terms of the particular goods and the particular clause in her contract than the discussion that we're having today. The discussion we're having today is whether the respondent's use of child labour in one of their plans constitutes a breach of this contract. Indeed, it could have been entirely foreseeable that Gertrude Schnippel was avoiding the contract because the goods she was referring to may well have been produced or provided to her by the claimant, not necessarily under this particular contract, so it's simply not relevant evidence.
Perhaps one question was with respect to remoteness in this context. You have settled your claim with Oceania Enterprises, and so part of your claim is damages up there. Why should the obligation not to use child labor protect also the shareholder of Oceania Enterprises?
Professor Brodermann, it's not for me today to run arguments in regards to the quantum of damages. Indeed,
it's not about quantum, it's about whether it's too remote or not.
I understand there is some overlap with whether or not remoteness goes to the particular liability. However, our submission is that the question here of the particular damage is not relevant. The question here of whether or not remote is not relevant. The question is is whether or not the use of child labour in their business constitutes a breach of either Clause 12 or 35(2)(b) of the CISG. In and of themselves, any questions of remoteness would indeed be determined as a question of quantum of damages, and I would remind Professor Brodermann that it's not only that share price reduction, but also other damages that are sought, and indeed will present arguments in a subsequent hearing.
The point you're making is understood. Let me concur 1 minute with my half a minute. Mrs. Ing, before we move to the next point, do you have any last comment to make on what you just heard?
Yes, indeed. Mr. President and members of the tribunal, first, we understand that particular purpose initially alleged is that of sale to the group. However, in this regard, we've already argued that a particular purpose must relate to the goods. And I shan't bother the tribunal again with a repeat of my arguments. The second is in regard to the letter that has been quoted by the respondent. It does not matter what the domiciliary's claim was grounded upon, because the sentence I just referred the tribunal to refers to a violation of the policy quite explicitly. And because domiciliary does share the same ethical policy with the claimant, it is enough that that sentence was talking about an interpretation or an understanding of that policy. And therefore, the meeting of minds of the parties, the respondent and the claimant, is on a narrower application of Clause 12. As regards the remoteness of the damages, it is indeed the respondent's argument that claims by the Children's Protection Fund is unforeseeable. This is because the respondent had no independent knowledge of the relationship between the claimant and Oceania Plus Enterprises. This is stated in the statement of the claimant, also stated in clarification 1. Oceania Plus Enterprises and the claimant has always operated separately as individual companies. And finally, if I may implore the tribunal that the opposing counsel has indeed told a story on rather fancy inferences of the facts. However, we humbly request that the tribunal decide this case on the law. And on that basis, there has been no fundamental breach because of the use of child labor.
Thank you, Mrs. Ing. We have well understood, and I think the tribunal has heard enough now on this very important point. And there are some time constraints, so we suggest that we move on now to the next issue. And the next issue being, from the perspective of the tribunal, that we would like to invite a respondent first to explain us why we should consider another date than the date set forth in the contract. The tribunal is aware that there are a number of legal issues which you made in your various briefs on that point, and we invite you to divide your time in what you want to tell us on that point. You can assume that we have read all your briefs. What we are most interested in for the remaining time of this hearing is to hear some clarification about the so-called Article 96 choice of law issue. Respondent, please proceed. I presume that this time Mr.
Yes. Thank you, Mr. President and members of the tribunal. As my co-counsel has stated, this case is about intention. And the intention of the parties was to apply the CISG without regard to any national reservation. And that choice must be respected by this tribunal. I first refer this tribunal to page 13 of the record. Clause 20 of the contract is the applicable law clause. And as this tribunal will note, Clause 20 of this contract is a direct copy of Article 35(1)(b) of the Sea Acts. And Article 35(1)(b) of the Sea Acts was designed specifically to derogate from the Article 96 reservation and effect of Article 12. According to Thomas Biden and Christine Heeg, in their article, The Arbitration Agreement and Arbitrability, Sea Act Arbitration, Bridging the Gap Between China and Europe, 2013, On page 146, they state, and I quote, "The SEAC model clause was meant to be applied as rules of law. The selection of rules of law by the parties allowed the parties to even derogate from mandatory provisions such as Article 12 CISG. And therefore, both the SEAC drafters and the parties intended for Clause 20 to apply as rules of law. When the parties choose rules of law, they are free to include or exclude any provisions they want, even mandatory provisions. For example, according to Barraclough and Weinstein, in their article Mandatory Rules of Law in International Commercial Arbitration, 2005, Melbourne Journal of International Law, on page 17, he states that it is possible to exclude a mandatory provision if, alongside the choice of lex contractus, sits an express exclusion of its mandatory provisions. And here, the phrase, without regard to any national reservation, does exactly that. As a result, the choice of the parties is clear. They wanted to choose rules of law, and they wanted to apply the CISG.
Sorry, I have a small question for the, apologize to interfere, Council, but could you explain, am I right in understanding, or am I misunderstanding, that you argue whatever is the contents of mandatory law, I can derogate from it? So if it's a law on child labor, on crime, on antitrust, I can say I do it without it?
Mr. President, in that situation, it's important to distinguish between mandatory law and overriding mandatory rules. Mandatory rules may be expressly derogated from by the parties. Overriding mandatory rules cannot be. However, in order to apply an overriding mandatory rule, the tribunal needs to take into consideration two factors. One, does the rule actually classify as an overriding mandatory rule? In other words, is it crucial for safeguarding a country's political, social, or economic interests? Even if it does classify as an overriding mandatory rule, does it have a sufficiently close connection with the dispute at hand? Here, both of these questions need to be answered in the negative. Firstly, a form requirement cannot be considered on the level of antitrust or competition law, and therefore it does not classify as an overriding mandatory rule. In fact, according to Professor Ulrich Schroeter, in his article, The Cross-Border Freedom of Forum Principle Under Reservation, The Role of Articles 12 and 96 CISG in Theory and Practice, 2012, page 34, he states, and I quote, "It is unlikely that form requirements for international sales contracts will fall into this category." And as a result, the first question must be answered in the negative. Second, there must be a sufficiently close connection with the dispute at hand. Here, Article 96 and Article 12 are given effect by Mediterranean domestic policy. However, Mediterranean must be considered by this tribunal only as one of the potential enforcement jurisdictions for this arbitration. However, if an award were to be enforced in Mediterranean, it would necessarily be in favor of the respondent. As there is no counterclaim in this matter, that award would only be in terms of costs. And here, this arbitral tribunal need not be worried about costs, because according to Article 43 of the SEAC rules, such costs can be placed in a trust account. And in fact, referring this tribunal to page 30 of the record, we can see that the SEAC administration has already acknowledged receipt of 100% of the arbitrator's fees. So there is no need to worry, the arbitrators will still get paid.
Thank you very much for this clarification.
Therefore, there is no risk of enforcement here. If the tribunal were worried about costs being enforced, it would be simple for the SEAC administration to simply order a further advance on costs. Those may be placed in the trust account. And as a result, Mediterranean and its domestic rules fall out of the picture. Therefore, Therefore, this tribunal should apply the rules of law as chosen by the parties, and that choice was to apply the CISG without regard to any national reservation. Thank you.
Can I just ask a further question? Let's suppose for the moment that you're wrong in a major proposition, and that by incorporating as applicable law the CISG with mandatory rules that say there shall be no derogation, that you couldn't, as it were, have the effect on the contract which you're contending for. Is the fact that the applicable national law referred to in the last phrase of paragraph 20 of the agreement, is that of any relevance?
No, Mr. Arbitrator, because if the phrase without regard to national reservation is to be disregarded, then this creates a gap in the CISG. Articles 11, 29, and Part 2 of the CISG are excluded.
Yes.
But according to Article 7, subsection 2 of the CISG, the tribunal should then apply the rules of private international law. Here, that means an application of the closest connection test. And according to clarification 33 and procedural order 2, that closest connection test takes into account two factors. One, where was the contract signed? And second, where was the particular performance of the contract? Here, both of those factors lead to equatoriality. Therefore, the rules of private international law also lead to a non-reservation scheme.
Thank you.
I think we should invite the claimant now to see what the occurs with your estate.
Members of the tribunal, I would like to preface my discussion of Article 96 by reminding this tribunal that the respondent need not only establish that no writing requirement applied, but that there was indeed no modification of the contract. It is the forceful and primary submission of the claimant that there was never any such modification. Because counsel for the respondent has turned attention to the issue of the Article 96 reservation, I will also address that now. And members of the tribunal, you have heard two strong, tenable arguments from the respondent about Article 96 and the choice of law clause. First, that there is arbitral consent, allows the respondent to make, or the parties to make a choice of rules of law. And secondly, that the closest connection test, if Article 96 applies, will take you to equatoriality. It's not quite as simple as that, members of the tribunal. I'll be demonstrating while there are a number of other alternative arguments that could lead you to the contrary result. But I'd also like to point out that the claimant will not be making argument on mandatory law, because indeed, if the tribunal were to turn to page 56 of the evidentiary record, that is clarification 34 on page 56. The only evidence before this tribunal is that the national contract law of Mediterraneo submits all international sales contracts to a form requirement. We don't know whether the state of Mediterraneo has the intention of having that form requirement as an internationally mandatory law. And indeed, if it was the Mediterranean state's intention to have its form requirement as an internationally mandatory law, then the claimant would be able to make submissions on that point, but there simply isn't the evidence before the tribunal today. So the arguments that I would like to make are in relation to the choice of Article 35 1b of the CIAC rules and the effect of that clause. What you have heard from the respondent is that when the parties chose the CISG without regard to any national reservation, that meant that Article 96 was excluded. And on first blush, that may appear to be the reading of the tribunal given. But in choosing the CISG, parties have agreed to Article 12 of the CISG, which stipulates parties may not derogate from or vary the effect of any Article 96 reservation. The following words in clause 20 of the contract, where they say without regard to any national reservation, make it appear at first blush as though the parties are intending to derogate from the very thing they have bound themselves not to derogate from. But the better view, I put it to you, tribunal, is to apply the general principle that parties intend their choice of law clause to be interpreted consistently, and that when the parties write the CISG without regard to any national reservation, they mean the CISG without regard to those national reservations that it is permissible to derogate from. And that would be every other reservation under the CISG, except for the Article 96 reservation. Now, I acknowledge, Tribunal, and I direct this particularly towards Professor Brodermann, who has an intimate association with SEAC, that was not SEAC's intention in drafting option B of Article 35.1. The intention of putting that clause into the SEAC rules was to circumvent the Article 96 reservation of China, which no longer matched the domestic form requirements in that country. There is difficulty in ascribing that same intention to the parties before you today, when one party comes from a country that has an Article 96 reservation that is in full force and domestic form requirements that...
Sorry, can I interrupt you for a moment? You were suggesting that the fact of exclusion of non-allowed reservations was in relation to such parts of the convention which parties could derogate from, as distinct from those which were mandatory, which they could not derogate from. Can you illustrate that by reference to any clause in the CISG, which does allow for voluntary derogation as distinct from mandatory?
Indeed, Article 6 of the CISG stipulates that the parties may modify or vary the effects of the CISG subject to Article 12, which safeguards Article 96. So under Article 6, the parties can change the CISG however they like, except for the Article 96 reservation. And so that is where it is permitted that they could derogate from the other reservations within the CISG. But even if Tribunal, you don't accept the argument that I've put forward that the intention of the parties was to derogate from the other reservations and not the Article 96 reservation, put it to you that when parties choose a convention that in Article 6 allows them to derogate from or vary the effects of almost everything in that convention, except for one thing, and there is only one mandatory provision in the CISG in which the parties may not derogate. It is not a selection of a cogent rule of law when the parties choose that convention and attempt to derogate from the only one thing that convention allows them not to derogate.
Mr. Sargent, may I interrupt you again with one other question in this context? What did the parties do? Did they really choose the convention, or did they choose something else? I'm relating a little bit to what consideration and impact should we give on the one side to Article 1 of the CISG, and on the other hand Article 28 of the Constitutional Model Law. What is the basis for all of that?
Indeed.
That was exactly the question.
We are all interested in knowing this.
Indeed, the CISG can either apply because it applies via a domestic law through Articles 1, Article 1.1 or Articles 1.1b of the CISG. Or alternatively, the parties may select the CISG as a choice of a rule of law under Article 28 of the Model Law, which I note has been modified by Article 35 of the CIAC rules, which allows choice of a rule of law. So the parties have chosen the convention as a rule of law, and it is my submission that when the parties choose a rule of law, that rule of law needs to be a cogent rule of law, and that when parties derogate from the very one thing that convention prohibits them from doing, that's not a cogent selection of a rule of law. But members of the Tribunal, I would like to remind you at this point in time that my primary submission is that there was no oral modification of the contract at all. I asked the question, would the Tribunal like me to address the issues raised by the respondent in the alternative that if Article 96 does apply, a closest connection test would take the Tribunal to Equatoriana, or would you like me to address the substantive issue of whether the contract was indeed modified?
I think we are in consent, and we realize that there was some consent. We have seen the witness statement, and I think that's procedural issues which we can tackle. So looking at my arbitrator, unless you have a question.
Just response to the matter that put to Mr. Ing.
Right.
In particular, if you're right that the mandatory rule on derogation from Article, by virtue of Article 12 of Wellhouse, don't you have a situation simply that Article 12 says that Article 29, which positively allows amendment or modification orally, does not apply? So you simply have a gap, and you're not then left with a situation in which, to fill that gap, you have to go to the system of law with which the contract has the closest connection.
Indeed, Tribunal, if the Article 96 reservation does apply, this is the question, that if the Article 96 reservation does apply, what the Article 96 reservation provides is that the freedom from form provisions in the CISG, that is Articles 11 and 29, do not apply. And indeed, I acknowledge that on plain meaning it doesn't say what applies in its stead, whether it is a matter of going automatically to the reservation states law or a matter of going to a conflict of law test through the gap-filling mechanism of Article 7.2 of the CISG. There are two schools of thought, and scholars are divided on this point. Those who advocate for going to a conflicts of law test do so on the basis that the plain meaning leads to a gap-filling approach. Those who advocate for what has sometimes been called the minority approach, or the approach of going to the reservation state, do so on the basis that it was the legislative intent of those states, those reservation states signing up to the CISG, that their reservations and their form requirements would be respected, and that therefore the appropriate avenue to take is to go to the reservation states form requirement directly. Indeed, Tribunal, I would submit that because Article 96 isn't clear as to the outcome, whether you go to a conflict of law test or whether you go directly to the reservation state, in this matter it's ambiguous, and regard may be had under Article 32 of the Vienna Convention on the Law of Treaties to supplementary means of interpretation, which include the travel preparatoire or the drafting history of the CISG. And that drafting history indicates that it was the intention of reservation states when they were signing up to the CISG, and other states were trying to get them on board, that their form requirements would be observed and respected. And in that regard, I urge the Tribunal to say that the state of Mediterranean's form requirements ought to be regarded. Are there further questions on that?
Yes, actually we would like, this Tribunal would like to continue on this issue in part for the moment, and if necessary, delete entirely for the purpose of this hearing these other issues, have been very well clarified in the various briefs. Unless it is of private ones for you to plead them, then we would grant that time for you. But if you would damp what the wishes of the Tribunal, we would be happy to more concentrate on this issue.
Certainly, Tribunal. I will then briefly address the issue raised by the respondent in relation to the closest connection test. If the Tribunal were to adopt the approach advocated by Mr. Ng, that it is appropriate to go to a conflict of laws test rather than go straight to the form requirement of the reservation state, it is undisputed between the parties that all parties come from states that apply the closest connection test, and therefore it would be appropriate for the Tribunal to apply that test. You've heard a plethora of reasons from the respondent why a closest connection test would lead you to the state of Equatoriana. Again, it's not quite so clear because there are matters of fact that we do not know. Although we know that, for example, the respondent is located in the state of Equatoriana and the goods were delivered to a port in Equatoriana, we know that the respondent in making the goods sought a large number of its supplies from suppliers, and we don't know where those suppliers are located, so that could be another telling factor which we do not know. But I wish in my positive submissions to put two things to this tribunal. The first is we submit that in this instance where the issue is about modification of the contract, it is appropriate to ask what is the closest connection to the agreement to modify the contract or the modified contract. And this would lead to the state of Equatoriano. The reason for this is that, this would lead to the state of Mediterraneo. I do apologise. This is because if you accept that the contract is modified, understanding that this is an alternative argument to my submission, but it's not. If you accept that the contract was modified, everything that had to be done under the modified contract had to be done in Mediterraneo, because the claimant had to reorganise the shipping contract, and the claimant was located in Mediterraneo and would have been doing so in Mediterraneo. The claimant had to go to its bank, located in Mediterraneo, to amend the letter of credit, and it had to organise agents to be present at the port to accept delivery. This all would have been organised out of Mediterraneo, so it is least open to the tribunal to find that the closest connection to the modified contract is the state of Mediterraneo.
Thank you very much, Mr. Sergio. Mr. Ing, you're looking so eager. Does it convince you?
Mr. President, members of the tribunal, I have 2 points. First, in regards to the Article 96 reservation, and second, to the closest connection test. In regards to the Article 96 reservation, the opposing counsel stated that it is in fact meant for China. That is true. But China's Article 96 reservation still remains in force. Although China withdrew from the reservation in January 2013 pursuant to Article 99 of the CISG, it remains in force for another 6 months. Here, the Article 96 reservation still stands, so there is no difference between Mediterraneo and China. The opposing counsel, by stating that the Mediterraneo's domestic requirements are different, is essentially stating that Mediterraneo's domestic policy forms an overriding mandatory rule, something which the opposing counsel has already conceded doesn't exist. Coming to the second point, in regards to the closest connection, the opposing counsel has regarded the facts that we don't know. Here's what we know. The contract was signed in Equatoriana. The goods were produced in Equatoriana. Since all tangible assets of the respondent were in Equatoriana, the characteristic place of performance must have been Equatoriana. The opposing counsel attempts to make arguments based on fancy inferences of the facts, based on modification, for example, of the letter of credit. But under UCP 600, which is the accepted commercial practices, even if the opposing counsel's client did have to amend the letter of credit, it would still have to be accepted by the respondent. Both of these factors don't decide the issue either way. They also stated that we must look at where the amendment was completed. Well, if Mr. Long was making the phone call, and Mr. Short was the one receiving it, and Mr. Short was the one who accepted the amendment, general law tends to go to the place where that contract was concluded, which is the recipient of that phone call. And in this case, those factors also lead to Equatoriana. But both of those try to detract from what this tribunal should look at. Where was the contract concluded, and where was the characteristic performance? Answering those 2 questions, that goes to Equatoriana.
We have understood both sides' argument with respect to the alternative argument, how to fill a gap if there is a gap. But the tribunal would nonetheless come back to the issue whether there is a gap at all, and I would like to draw the attention of both counsels to Article 28 of the Unzittarbare law. And the question is this: should the tribunal draw anything out of the context that under that law it is not only possible to choose rules of law, but even to make ex equo and bono decisions if you're being appointed, if you're being told so. So if you look at this Article 20 in the contract, the question is whether implicitly we are somehow instructed not to give regard to any national reservation. And I think this question goes first to you, Mr.
I don't quite understand, because there is a bit of an echo with the microphone. What the question? I missed some of the words.
The question is, in essence, because 28 even grants the possibility to allow ex equo et bono decisions if the parties wish to behave so, whether you take any lead out of that in interpreting your Article 20 of your contract, which says no regard to national reservation. Why should we act differently?
Indeed, Tribunal, I believe believe that Article 28 of the model law is not a mandatory provision of the model law in the same vein that Article 18 of the model law is. And the parties under Article 19 of the model law have the ability to choose the rules that will govern the arbitration. They've chosen the SEAC rules, and Article 35 of the SEAC rules quite thoroughly deals with the issue of what is the permissible choice of law. So it is my submission that Article 28 of the model law is superseded or modified by Article 35 of SEAC, and the parties have made their choice under SEAC. There are other options under SEAC where the parties could choose to allow the tribunal to choose what they think is the appropriate law, or ex equo et bono. The parties have not chosen that, they've chosen option B. And what I merely sought to put before the tribunal when I made my submissions about this phrase, the CISG, without regard to any national reservations, that SEAC's intention was to override the Article 96 reservation of China. But the question before the tribunal is what was the intent of the parties when they put that into Clause 20? And I made the point that when one of those parties came from a reservation state, it wasn't necessarily their intention to derogate from the effect of Article 96, and that an alternative interpretation would have been given to that choice of law clause.
Does this elevate the SEAC rules in the sense that they are no longer just procedural rules for the arbitration?
The SEAC rules are the procedural rules for the arbitration. The way in which the tribunal goes about selecting the substantive law that it shall apply to the contract, in other words, selecting the lex contractus, that is a procedural matter. So the procedural rules dictate how the lex contractus is to be selected. And so Article 35 of the SEAC rules should therefore modify or supersede Article 28 of the model law, unless Article 28 is a mandatory provision, and it isn't a mandatory provision of the model law, in the same vein that Article 18 of the model law is.
But you do wish in the end, just to understand you rightly, that we find against the wording to which your party signed on first.
Sorry, you said that?
You kind of want us to switch. First you signed without regard to national reservation, and now you say we have to find that nonetheless that applies.
What my first submission was that without regard to any national reservation would be read as still being consistent with having the Article 96 reservation in force. The second submission was that even if the tribunal didn't give that phrase, that interpretation, that nevertheless the SEAC rules dictate that the parties must choose rules of law, and that must mean cogent rules of law, and that when the parties attempted to select the CISG without the very one mandatory provision that it has in it, that wasn't a selection of a cogent rule of law. It's merely open for the tribunal to find in that regard.
So I think we understood your point. Do my co-auditors have any questions at this point? Then I would like to invite both parties very shortly to kind of make a final comment, a final statement on any issue which they still may wish to emphasize. I think we start with Eckart.
If by these final submissions you'd like to hear on the modification of the contract, perhaps it may be better to hear from the respondent first, since the respondent is alleging that there was a modification, but otherwise I'm quite happy to start first either way.
Okay. Good choice.
Okay. Members of the tribunal, the claimant is here to make a claim for $27,500 for the late delivery of the polo shirts, which were delivered 5 days late. Clause 10 of the contract, they're entitled to a 5% deduction, and that it is not disputed by the parties that this would be payable unless there was an oral modification of the contract. There has not been such an oral modification of the contract, and the respondent bears the burden of establishing that there was one under Article 27.1 of the SEAC rules, which say that the parties bear the burden of establishing the facts on which they base their claim of defence. Members of the tribunal, I put it to you that the conversation between Mr. Short and Mr. Long on the 9th of February was nothing more than a conversation that had to happen under a contract which included clause 10, which enabled the respondent to deliver late subject to a reduction in price, and which incorporated the FAS Incoterms. The reason for this is this. Under the FAS Incoterms, the claimant was responsible for having a ship at a port on a designated date, and the respondent was responsible for delivering the goods to that designated port on that designated date. If Mr. Short calls up to inform the claimant, as he did, of a necessary delay in delivery, then there needs to be an adjustment. There needs to be communication, because the claimant has to go away and cancel the ship that was going to be there on the 19th and rearrange a ship to be there on the 24th. They need someone to be there at the dock on the 24th to take delivery of the goods. These are logistical arrangements that need to happen. And so, when... go ahead.
Very short question in this context. Is there room for the application of damages for delay in addition to the avoidance of the entire contract?
Indeed, Tribunal, I would submit that the proper characterisation of Clause 10 is as a liquidated damages clause. And under Clause 10, that the 27,500 claim is made out. Thus, the right to liquidated damages had crystallised by the time of the avoidance of the contract. And if that right to damages had crystallised at the time of the avoidance, then it can still be claimed afterwards, or at least that amount can be claimed as part of the quantum that was claimed through the avoidance. So yes, the two claims can be made out and claimed concurrently.
Are you finished then? Then I would like to ask Mrs. Ng to make some kind of final comments.
Mr. President and members of the tribunal, the respondent has 2 points in reply to the opposing counsel's arguments on an amendment of the contract. The opposing counsel first relied on the conversation between Mr. Short and Mr. Long to say that there had been no amendment. Suffice it to mention in passing that it is the opposing counsel who is now not objecting to the admission of Mr. Short's statement as he referred to it. But more important, the respondent's argument is that actions speak louder than words. According to Article 8.2, the intentions of the parties should be understood in light of their conduct and their statement, and their understanding upon that of a reasonable person's understanding. In this argument, the respondent relies on 2 facts. First, the claimant took delivery of the polo shirts without any objections on the 24th. Second, they made full payment for the polo shirts by virtue of an amended letter of credit. According to the Stafford International BV and IXMA CPI case, Commercial Court of Belgium, 2005, where the court was discussing how conduct might count as acceptance, in paragraph 2D, it said this: conduct that implies the performance of the contract, that is, payment or acceptance of the goods without protest, suffices. On the facts of this case, the claimant has done both. The opposing counsel then referred to the Incoterms and said that they made payment because it was an obligation of the buyer under those terms. However, the respondent argues that the fact they made payment and failed to make a claim for the deductions only 18 months after the 24th of February shows by subsequent conduct that their intention was to change the delivery date.
Excuse me, Mrs. Is it not true that we have a letter that says we reserve our rights in all respect to all remedies available to us?
Indeed, Madam Arbitrator, there is such a letter. The letter, in the end, did say that it reserved rights to other remedies. However, the tribunal might also note that the letter overwhelmingly was intended to address the issue of child labour, and that it did not mention the deductions explicitly. A reasonable understanding of a person in the respondent's shoes would expect that over these 18 months after the goods were delivered on the 24th, something would have been said about those deductions. Nothing was said until the notice of arbitration was entered on the 1st of July 2012. And according to Article 83, in determining the intent of a party or understanding of a reasonable person, we are entitled to look at all the relevant circumstances of the case, and that includes, and I quote, any subsequent conduct of the parties. Such subsequent conduct of not making any reference of any claim until 18 months later shows that the reason is because there was no late delivery and the incentives clause was not triggered. Yes.
We've taken that point. I think Mr. Stewart Sergeant wants to add last point.
Indeed, Tribunal.
Very short, please. Max 1 minute.
Counsel for the respondent has pointed out that acceptance of payment by a letter of credit can amount to an acceptance of an offer to modify a contract. And I have no doubt that that can be the case. The question is, on the facts of this case, was that what happened? And in this contract, which has Clause 2, that cannot be the reading. Clause 2 of this contract imposes an obligation on the claimant to make payment of $550,000 by way of letter of credit. It does not cross-reference Clause 10. It does not set off against Clause 10. Therefore, there's an obligation to pay $550,000, and the claim for $27,500 is to be paid separately. So the letter of credit not being accepted is no evidence of an amendment.
Thank you. Does any of my forward address have anything last question? No? Then I would like to put one last question to both counsels. We have in previous occasions discussed the possibility of settlement. And are we correct, or do we need correction in understanding that you still want an award and that you still do not contemplate to meet now the settlement?
Members of the Tribunal, I would be rather frustrated if my efforts today did not go towards an ultimate award from this Tribunal, so I do request one.
Respondent.
Mr. President, members of the Tribunal, I have 3 reasons why we cannot take a settlement at this point. First, we are in arbitration and the arguments have been done. We are past the point of settlement. Second, I have no instructions for my client. But thirdly, and most importantly, I really need the work.
Under these circumstances, we thank you very, very much. The Tribunal will now retire for deliberation and will, under these special circumstances, see and make our award still during this day. Thank you.
Thank you very much. Before everyone moves, I have some very important announcements. It is extremely important that you leave this room in an orderly fashion now through the doors to the rear of the room, taking every single piece of your belongings with you.